Hi everyone, welcome to another episode of Ask a Property Manager. This is episode number 61 and today is March 3rd, 2021. We're coming to you from Studio 2.0 here at Own Buffalo. I'm Andrew Schultz, Principal Broker of Own Buffalo, Inc. And on today's show, we're going to be updating you on eviction moratoriums. We're also going to be talking about how to handle a tenant that disputes their security deposit refund. We'll talk a little bit about snow, and we'll answer some questions from landlords and housing providers around the country. Before we jump into all that, we're going to go ahead and plug our social media. New episodes of Ask a Property Manager every Wednesday, 10 a.m. Eastern, live on our Facebook page. You can catch the replay the same day on our YouTube page as well as on Facebook. And don't forget about our Instagram as well. Don't forget about the Rent Prep for Landlords podcast. We are, let me see, is this a new episode this week? No, this is the off week. So don't miss the current episode of the Rent Prep for Landlords podcast. We're taking a look at coin-operated laundry in rental properties. We're talking about how to go about renovating an apartment while a tenant is still living in the apartment. We're also discussing the purchase and use of a home warranty, as well as, sorry, no, this is not the home warranty episode. This is the episode where we talk about the purchasing a home that has bad tenants, but the deal is a good deal. So it's a pretty good episode. Don't miss out on this one. New episodes of the Rent Prep for Landlords podcast drop every other Thursday. So there'll be a brand new episode next week on Thursday. But the current episode is up and available over at rentprep.com/podcast or anywhere that podcasts are heard. So we're going to jump into our news of the day. It's actually going to be pretty extensive talk about evictions today, both on the federal level, then here at the New York State level. We're going to cover a few different articles today, and then we'll jump into our questions. So this first one that I wanted to bring up is that a Texas judge has found the national eviction ban unconstitutional. And we'll go ahead and jump into this article. This one's from CNBC, and this was published at the tail end of last week on Friday. Federal judge in Texas has ruled that the national ban on evictions that has been in place since September is unconstitutional. Although the COVID-19 pandemic persists, so does the Constitution, U.S. District Judge John Barker wrote Thursday evening, siding with a group of property managers who argued that the ban exceeds the power of the federal government. The CDC, the Center for Disease Control and Prevention's National Eviction Moratorium was first announced under former President Donald Trump in September 2020. It prohibited evicting renters who were financially struggling because of the coronavirus pandemic. President Joe Biden has since extended the moratorium through March and has called for it to be kept in effect through September 2021. The CDC did not immediately respond to a request for comment. Landlords have criticized the CDC moratorium, saying the government was overstepping its authority and that they can't afford to house non-paying tenants. There have also been court challenges to the moratorium in Georgia, Louisiana, and Tennessee, though they were all unsuccessful. Advocates of the ban quickly slammed the ruling and feared it would trigger a flood of eviction filings. The winter storms have led to massive power outages across Texas will only worsen the condition, they say. This decision is a major deviation from all other district court decisions that have upheld the CDC moratorium as constitutional, said Emily Benfer, a visiting professor of law at Wake Forest University. The CDC moratorium is a critical pandemic mitigation measure that protects health and safety by preventing the community spread of COVID-19 due to eviction, she said. Indeed, research has found that evictions lead to significantly more coronavirus cases and deaths in an area. By one estimate, there were worries about paying rent in more than 1.7 million households in Texas during the pandemic. The judge in Texas hasn't issued an injunction yet, though he suggested he later could. Such a move would leave millions of Americans at risk of eviction. Advocates hope the White House will intervene quickly. All eyes are now on the Biden administration to see how and if they plan to vigorously defend the CDC eviction moratorium in the courts, said Diane Yentl, president and CEO of the National Low Income Housing Coalition. So I bring this article to everybody's attention just so that we're aware of what's happening on the national stage more than anything else. But realistically speaking, keep in mind that even though one judge has said that this is an unconstitutional ban, this eviction moratorium is an unconstitutional piece of legislation or whatever you want to call it, there's a long road that this has to go down before any real headway is made. This is going to get fought all the way up, probably the Supreme Court, I would assume, which will likely take an extended period of time. And by the time they're done fighting this thing out, we'll probably be past the end of September anyway. So this has been one of the articles that's been floating around hot and heavy this week, talking about this national eviction ban being found unconstitutional. That's great, but we still have a long way to go. Don't count on this as being the silver bullet to all of your problems when it comes to landlord-tenant issues. So we do have a long way to go. It sounds like there at least are some people who are fighting this. We'll see where it winds up. So we're going to turn a little bit more into New York State. This article was pulled from The Real Deal, which is a New York City-based, I don't know if I would call them a newspaper or what have you, but this is in regards to Governor Cuomo here in New York losing his temporary powers, but still having authority to extend COVID restrictions. I'm actually going to blow this up a little bit. State legislator has reached an agreement to strip Governor Andrew Cuomo of his emergency powers granted to him during the pandemic, but leaves the door open for him to extend COVID-related restrictions, including limits on indoor dining. Roughly a year after expanding the governor's executive powers to oversee the state's pandemic response, the Senate and Assembly are moving to cut off the politically weakened governor. The chambers are expected to approve a measure that would prevent Cuomo from issuing new directives, but would allow him to extend existing ones that manage the spread or reduction of COVID-19, facilitate the vaccination process, or require use of face coverings. I think everyone understands where we were back in March and where we are now, Stewart's cousin said in a statement. We certainly see the need for a quick response, but also want to move toward a system of increased oversight and review. The public deserves to have checks and balances. Early in the pandemic, the governor unilaterally shut down entire industries and then gradually laid out rules for them to reopen. For most of the past year, he limited residential and commercial evictions, issuing orders that at times conflicted with guidance from state courts. His last order related to residential evictions expired in December, supplemented by a law that banned most evictions through last week. Tenants can seek further protection through May 1 if they fill out a financial hardship declaration form. That'll be the next article we cover. Stay tuned for that. The fate of commercial evictions is less clear. The governor's last action on the matter expired last week, and there's disagreement over whether a recent order extended the ban through March 24th. In late January, the legislature passed a bill that would bar commercial evictions and foreclosures through May, but the governor has yet to sign it. Once the legislature passes its bill to take away Cuomo's emergency powers, the governor must notify Senate and Assembly leaders before extending existing orders and give them an opportunity to comment. In cases where orders solely affect a specific area, such as in-dining restrictions in the city, the governor must notify the local government. Last week, Cuomo raised capacity for indoor dining in the city to 35%. Restaurants elsewhere in the state, such as upstate, are able to operate at 50% capacity. Calls to remove the governor's emergency powers began as early as late last year, but have picked up as 3 women accused Cuomo of sexual harassment, and an investigation found that he had underreported the number of nursing home residents who died of COVID. But the legislator has always had the power to block any of Cuomo's COVID orders, which have drawn objections and lawsuits from restaurants, fitness centers, bowling alleys, and other businesses. Not once has it done so. So really, I bring this article up because it does mention the residential eviction piece here. And really, that's what I wanted to use to bring us into our next article, which talks about the eviction moratorium. So this one is also from out of New York City. This is thecity.nyc. It is a newspaper. I'm going to call it a newspaper. I think it's probably just digital. But this article talks about the eviction moratorium pause ending February 26th. And here's what you need to do. This article has information for both landlords and tenants. So if you're a landlord and you're watching this, you're going to understand, okay, here's my options right now. If you're a tenant and you're watching this, you're going to understand, okay, here's what I have as far as options right now. This article kind of goes in both directions, which is why I wanted to use this article. I haven't spent a ton of time verifying everything that's in here yet, so please bear with me if something is in here that's not 100% correct. Definitely speak with your legal team before making a decision as to whether or not you want to proceed with an eviction. Or if you're a tenant, there are certainly numerous resources out there for you to obtain either rental assistance or legal assistance, depending on what you need. All of that being said, let's jump into this article. And again, this is coming out of New York City, but this should apply across the state. Eviction moratorium pause ends February 26th. Here's what you need to do. Go ahead and blow this up a little bit. When the state legislature passed the Emergency Eviction Act at the end of last year, nearly all eviction proceedings were paused for 60 days. That pause ends on Friday, February 26th. After February 26th, pending eviction cases can start moving forward again in court, and new cases can be filed unless a tenant submits a hardship declaration form to either the court or the landlord. This means that any tenant facing eviction who haven't filled out the hardship declaration could start hearing from the courts, and landlords can start new cases against tenants behind on rent who haven't filed a declaration. Here's what tenants need to know about Friday's deadline as it approaches. Hold up, I thought the eviction moratorium was until May 1. The moratorium is extended until May 1 only for tenants who fill out the hardship declaration. From the end of December until now, almost all tenants were protected from eviction because cases were paused. But after February 26th, the moratorium protections only cover tenants who submit the hardship deck. Justin Lamort, a tenant attorney at Mobilization for Justice, said the true moratorium ends the 26th, February 26th. Then it's only those who have done the declaration who are protected. You are not protected until you take action. You can fill out the form at any point before May 1, up until when the marshal shows up at your door to pause your eviction. Do I have to have the eviction filed against me already to fill out this form? No. Anyone who can say that they've experienced some type of financial hardship because of the pandemic or that needing to move would pose a health risk can fill out the form. The moratorium covers a wide variety of situations people are facing. When the moratorium was passed, housing advocates noted that a person can fill out the hardship form before his case is filed to prevent having to appear in court until at least May. How many people have filled out the form already? According to the Office of Court Administration, 6,800 people in New York State have filed hardship declarations with the courts. From that, more than 5,000 were for pending eviction, and about 1,000 were to prevent cases that had not yet been filed. Those numbers are just for the people who sent hardship declarations to the courts and don't reflect the number of people who sent the form directly to their landlords to prevent a future case. Housing advocates worry that not enough tenants know about the form or how to submit it. They are also concerned that the number of forms submitted is much lower than the number of New Yorkers who have struggled to pay rent and need protection from eviction during the pandemic. Lamort said, anytime you can create a system where tenants have to jump through hoops, you're going to lose people. Kim Statuto, a tenant leader with Community Action for Safe Apartments in the Bronx, said, that's a very small number compared to what we're going through and what people are going through. People need to know that this is an option for them, and it may help a family rest a little bit easier. How do I go about filling out the hardship declaration form? To make the process easier, 3 housing organizations work together to make a tool called Eviction Free NY, where tenants can fill out the form and submit online. It's available in English and Spanish, and you can use the drop-down menu to find the form in more languages through an online housing form, Housing Justice for All. Scrolling down a little bit further, talks about the tool that a tenant can use that tool to actually basically fill the form for them so they can send it to the court or to the landlord. And then moving on a little bit, I want to see if there's anything else that needs covered in here. Yeah, that's pretty much the end of what I wanted to cover here. It just goes into some information about New York City here. So essentially why I wanted to cover this article is because there is an opportunity for landlords. If you've not yet received any sort of a hardship declaration from your tenants, you may be able to speak to your attorney and begin that process of an eviction. Just understand the fact that if you do get a hardship declaration, it's either gets sent to you, gets sent to the court. Possibly even if it's sent to the attorney, I think that they would probably say, okay, well, your attorney received it. Obviously, your attorney told you they received it, sort of a thing. But the way that it is written, it has to be presented to either the court or to the landlord. And then that basically puts everything back on pause to May 1. So might be an opportunity here if you are in a circumstance where a tenant has not provided you with that declaration yet, you may be able to move forward. Keep in mind that there are new rules with regards to how things need to be served to tenants, including the declaration paperwork that has to be served, as well as a list of opportunities for tenants to be able to get some assistance for rental assistance. Essentially, you're going to want to talk to an actual attorney. Like, people who are trying to do evictions in the state of New York right now on their own that are not attorneys are absolutely insane in my mind. Can it be done? Yeah, probably. But do you really want to be spending your time and energy basically learning everything that you need to know about law just for this one instance? You're much better off spending the money on an attorney to handle this situation for you, because at least then you know that it'll be handled the correct way and you're not going to trip over something small in the language that causes you to have to, go back 3 steps or restart the entire process from scratch or have your case thrown out of court altogether. Hire an attorney, do it the right way this time. I understand that, there's an opportunity for landlords to do evictions on their own. This is not the time to do it. Just let a professional handle it. Get it done the right way. If you're in the Western New York region, I would say Buffalo, Erie County, Niagara County. I've got good attorney referrals. I also have a good attorney referral in the Rochester area, Monroe County, so that might be an option. If you are looking for an attorney referral, please feel free to reach out. We can be reached here in our office, 716-608-3200, or you can drop us a message on Facebook or on YouTube. All right, that's enough for the eviction moratoriums for the day. Let's go ahead and look at something funny. So this is not from one of our apartments, thankfully, but I do know somebody who did something similar. They actually had like an inflatable hot tub in the basement of their building, the basement of the house that they were renting, and I couldn't believe it that they went through the length to put a hot tub in their basement, and just the moisture and mold concerns and stuff like that, totally insane. But yeah, this is actually not the first time I've seen somebody put an inflatable pool inside of a property, so definitely make sure that you're doing your biannual inspections. A little bit of construction humor for you. When a plumber leaves his coffee and the electrician has to run his line, that's what you wind up with. I thought that one was pretty funny. I thought that you guys might appreciate that one as well. We're going to jump into our questions from housing providers around the country, starting with this one on sticking to policy. We're debating in the office about this one. We mail physical statements to each unit/house at the end of each month showing how much they owe as of the 1st. We have one unit who has requested not to receive these statements. We're 50-50 split that if we have a procedure that we follow for all units, then by making an exception for one unit, we are going against some fair housing policy. What is your opinion on this? I don't know as though this would necessarily be a fair housing thing because the tenant is requesting that you not send the statement. All of that being said, if you have a policy, follow it each and every time. If they don't want a paper statement, send it digitally. Make a note on their tenant file that they requested a digital instead of a paper copy. There are people who just prefer paperless things. They want it in their email versus receiving a statement in the mail every month. And if that's the case, I think that's pretty reasonable. Just make a note of it that they requested digital as opposed to paper. But if you're sending statements out to everyone, send statements out to everyone. If a tenant complains, tell them, look, that's the company policy. We have to follow it. We have to send a statement somewhere. Do you want it in the mail or do you want it digital? But if you're following that policy, stick to the policy and follow it all the way across the board. I wouldn't deviate on something like that. There's really no need to. You can deliver it digitally. You can deliver it via paper, whatever the tenant's preference is. But I would say you should still be delivering that if that's what your policy is. Question number 2, security deposit dispositions. Former tenant owes money for damages. We gave them an itemized list with receipts and invoices from the contractors, and now he's contesting that some things weren't needed to replace a door like hinges and a frame. You've got to be kidding me. He thinks that he knows more than professional licensed contractors. How do you all deal with people like this? It's exhausting. So I'm going to assume that you've done your part, and it sounds like you have done your part, by providing the security deposit disposition along with any documentation that you're required to provide, receipts or whatever the case may be here, which it sounds like you've gone ahead and done all of that. And you've communicated all this to the tenant in writing. I'm not sure how the tenant is communicating back with you, if they're communicating in writing or if they're calling or texting or emailing or whatever the case may be. I would communicate with the tenant one last time in writing. Let the tenant know that if they wish to dispute your security deposit disposition, that they can submit any documentation that they want to help their case. Have them send it via email or postal mail or whatever the case may be, and give them a deadline for that to drop that paperwork or to get that documentation over to you. Then review it and send them a final determination letter. You may find that based on the information the tenant provides that you want to adjust your security deposit disposition letter. You may find that you don't want to adjust your disposition letter. Basically what I'm saying is look at whatever the evidence is that they have, consider it, understand that, hey, maybe we made a mistake. More than likely we charged exactly what we were supposed to charge for and we're not going to be making any modifications. But it gives the tenant the opportunity to be heard. It gives them the opportunity to submit any documentation they have to, try to argue this a little bit. And then once you've gone through the paperwork, made your determination, reviewed everything, send a final determination letter in whatever capacity, probably mail if you sent the first one via mail. Just send a final determination letter. Thank you for sending us your documentation. Based on the documentation provided, we've made X adjustments or we made no adjustments, blah, 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 blah. And then past that, beyond that, the tenant can take it up in court if they are so inclined, if they're not satisfied. That's what the court system is there for. It's up to the tenant if that's the route that they want to go. it's on them at that point. If they decide that they want to go to small claims court or something like that over their security deposit disposition, they're certainly entitled to do so. There's nothing that you're going to do to stop them from doing that. Just make sure that you're well documented with move in and move out photos, the invoices for any damages that were caused, the security deposit disposition letter. Just make sure that you have a good set of records if you do wind up in court so that you can fight that case. Typically speaking, most tenants won't actually go to small claims court, especially if you show them the documentation of, look, when you moved in, you had a brand new countertop, and when you moved out, there was a giant ring about the size of the bottom of a cooking pot on the counter right next to the stove. Obviously, that's damage, et cetera, et cetera. Most tenants, when presented with the actual evidence, won't bother to pursue it any further. But if you do have to go that extra step, if you do have to go to court, at least that way you know that you're protected and that you have all of your documentation in a row. Dealing with snow. I'm revising my snow removal clause to better describe what kind of snowfall would qualify. I have a property that requires a plow. I'd be interested to hear how other landlords handle this. This is college student rental with 6 able-bodied young people living in it. I think it's reasonable to do snow removal for a minimum of 3 inches, possibly 4. I would like to require the tenants to shovel the walk and around their cars. We do not have sidewalks. I'd welcome any examples or thoughts on this. So it sounds like you're having a plow service come in to handle the main driveway, if you will, or maybe the parking area. And then you're asking the tenants to handle basically the sidewalks, the steps, the area around their cars, which seems pretty reasonable to me. The way that we deal with snow here in our office is if it's a duplex or a single family, the tenants are responsible for snow. If it's anything larger than that, a triplex and up, we take care of the snow on our end. And I wanted to show you the actual clause out of our lease that indicates that we look for snow to be removed from sidewalks anytime there's 3 inches or more of accumulation. Stairs need to be kept clear of snow at all times, no matter how much accumulation, just for the slip and fall hazard. Rock salt should be used as necessary. Something else that I wanted to include here is the highlighted section down below. Apartment has a furnace in working condition, blah, blah, blah. If the furnace is high efficiency or side venting, meaning it's venting out the sidewall of the property, tenant is responsible for keeping objects, snow, and debris free from the air intake and vent areas. A buildup of snow, debris, or objects can lead to the furnace producing carbon monoxide, a colorless, odorless gas, which can be fatal. Now let me explain why that clause is in our lease. A few years back, we had a major snow event here in the city of Buffalo and the surrounding suburbs that dropped something like 7 foot of snow in Western New York. It was a lot of snow. We don't have a ton of high efficiency furnaces that side vent out the side of the property. Most of our furnaces are still 80% efficient that vent up through the chimney. The problem we were having was tenants that did have the side vent furnaces were not going out and clearing the area around the vents so that the furnace could still breathe and, inhale and exhale essentially. So the furnaces were shutting down so that basically, if it can't breathe in, it automatically trips a sensor and shuts itself down so that you don't start producing carbon monoxide poisoning. So that's something to keep in mind. If you do have a high efficiency furnace, make sure your tenants are aware of where the intake and the exhaust are and how to go about keeping those clear. It's certainly something that's worthwhile if you're in a cold weather climate and you get that high amount of snow. That could be the difference between frozen pipes and your house freezing solid, and the difference between that and your tenants being able to stay in the home and stay nice and safe and warm during a major snowstorm. So most of our snowplow contracts have a 3-inch threshold on them. Anytime there's more than 3 inches of accumulation, that's typically when our snowplow contracts kick in on the properties where we have to offer plowing. So that might be the point that you want to consider. Most plow contracts have a range somewhere from like 2 inches to 4 inches. Some commercial ones are even dry pavement, which is very, very expensive. So obviously, if you don't need that, I would not recommend it. So that pretty much wraps things up for this week's episode of the Ask a Property Manager Show. Thank you all so much for watching. We love producing Ask a Property Manager, and you can certainly help us to improve. Do us a favor and drop a question in the comments, either on Facebook or on YouTube, and your question may be answered in an upcoming episode. If you enjoyed this content, or if we brought some value to your day, please do us a favor and hit that thumbs up button. YouTube and Facebook both push videos based on community feedback, so every like, comment, subscribe, and share helps us to grow and reach more people. We'll be back next week on Wednesday, March 10th at 10 a.m. Eastern with another show you won't want to miss. Thank you all so much for watching, and we'll see you next week.